it's still legal under federal law. And they went into what this statute means and what it states. There's no exception in this statute for being lawful under state law or an exception under federal law. It's lawful, period. And courts will give basic terms, their basic definitions. So if it's lawful, it has to be lawful under state law, it has to be lawful under federal law. If the state legislature wanted to carve out an exception, they could have said who was engaged in lawful activity under state law. They didn't say that. The courts are not going to read or put in an additional definition into a statute. They're not going to do that. Now, Mr. Coates has appealed this case to the Colorado Supreme Court. Briefing is currently underway in this case. Oral argument is probably going to be, I would say, June or July of this year. And then they'll probably issue a decision in September or October. I think that the Supreme Court, the Colorado Supreme Court that is going to uphold this decision and hold that Dish Network had a right to terminate Mr. Coates' employment because his use of marijuana was not lawful. If, however, the Supreme Court were to reverse this decision and hold that Dish Network's right to terminate Mr. Coates was not a lawful, did violate this statute, that would really throw employment law, in particular substance abuse policies here in Colorado, up in the air. I just don't see that. I don't see that with the way that the state legislature is currently constituted, or not the state legislature, the Colorado Supreme Court is currently constituted. I would be shocked if that was the result, and I think that there would certainly be a movement in the legislature to try and change that, but we need to stay tuned.
Wasn't there a recent policy change, or maybe something even in law from the federal administration about allowing banks, which are federally regulated, to now process marijuana money in Colorado and Oregon because it basically turned into a cash business, which was very dangerous for the people working in it. Was there something recently on that?
There was, but in all that the administration, President Obama's administration, can do is relax the regulations. In order for that sort of banking activity to be legal, that is going to require an act of Congress.
Okay. What I'm getting at, though, then that may happen, is if I was this guy here and then I lost my appeals, I'd wait until they come back and say, banks can now handle marijuana money because they're making money off of it, but you're not letting me use it on the job. I think that might be unequal treatment under the law.
Well, let's talk about that, because you're going to get that argument. You're going to say, well, I've got a constitutional right to use my marijuana, employer, and you can't prevent me from using it. And my response is, guess what? Under Amendment 64, I have constitutional rights as your employer to have policies in my workplace restricting your use of marijuana, period. And also under Amendment 64, I can completely prohibit your possession and use of marijuana on my premises. So yeah, you might have a constitutional right to use marijuana off duty and off premises, but that doesn't give you a right to work at my company if I have a zero tolerance drug policy.
Isn't the real issue here that marijuana stays in the system? So if you use it lawfully, off-site, off-duty, that's great, but the fact that it's still in your blood 4 days later and can be detected in a blood test, that's a completely different issue. Because now it really doesn't matter what you did 4 days ago. What matters is that it's detectable in your blood today.
Right,
Which
as
means
long as
you are
it's
bringing
detectable.
which means you are bringing it onto the workplace,
Right.
whether it be in your blood or in your purse, you're still bringing it into the workplace. And to me, that seems to be the bottom line here.
That is the bottom line. I mean, the cutoff is, if you're going to use it, you're taking a risk. If your employer has a zero tolerance drug policy and you're going to use marijuana, you are taking a risk that you're not that it's not going to be detected in a drug test. And the bottom line is that under the law, under Amendment 64, the people who wrote Amendment 64, they put into Amendment 64 that you as an employer can have policies in your workplace restricting your employees' use of marijuana. And my argument to you is, if that means that you want to have a zero tolerance drug policy, you can have a zero tolerance drug policy. I have other clients up in the mountains, for instance, and they come to me and they're like, Vance, I can't have a zero tolerance drug policy. If I have a zero tolerance drug policy, I won't have a workforce. I have a hard enough time getting these guys to come in when it's a big powder day, let alone if I tell them that I'm going to start drug testing them and they test positive. So how do I deal with it? And my response is, treat it like you would alcohol under your substance abuse policy. Don't allow your employees to come to work drunk. Don't allow them to come to work stoned. You don't allow your employees to drink on their breaks. Don't allow them to consume marijuana on their breaks. You don't allow your employees to drink at lunch, do you? Do you? You shouldn't allow your employees to smoke marijuana.
So why in this case couldn't they just refer to that policy? So his case is that he did it lawfully off duty, but he can't prove that it was off duty. That's the point of the test.
It's in his blood.
That's in his blood. I mean, he's coming to
So
work.
that's what I'm saying, why couldn't they defer to that? Why did they have to fight the?
Because this
federal
is
statute
what
like
he
that?
sued under. This is the statute which he sued under. So the Colorado Supreme Court is going to analyze his use under this statute and is going to determine whether or not his use is protected under this statute. And for employers, we're going to argue that his use wasn't protected under this statute.
So we're assuming, and this is like the second layer of marijuana in particular, we're assuming that if it's in your system, you're under the influence.
Well, if it's in your system, if you have a zero tolerance drug policy, it's in the person's system, the person is violating your zero tolerance drug policy. Again, my advice to you is don't get into the argument of, oh, you weren't really impaired or under the influence. If you have a zero tolerance drug policy, you terminate their employment. If they come to work and you believe, you have reasonable suspicion that they're impaired or under the influence, then you can drug test them, and then if they test positive, you can terminate their employment.
Yeah, it's just, something seems so odd, because, for example, someone who does cocaine, within 2 days, that cocaine could be completely out of their system. And it just seems like there's something about it that just doesn't feel right.
Well, yeah, okay, and so the question is, or the comment is, you know, cocaine, somebody can use it and it can be out of their system in, say, 2 days. Whereas marijuana, it could stay in your system for, you know, 3 or 4 months, and in some instances, maybe 60, 70 days. And that's one of the reasons why the American Medical Association won't come out and take a position on marijuana, because they don't know the potency effects of marijuana. And that's part of the problem with taking these sorts of substances, folks, is that drugs, and there are different types of drugs will stay in your system for different lengths of time. If you take acid, for instance, acid, you can have flashbacks years later. You can be driving a truck down the middle of the street and have an acid flashback and cause an accident. Because the problem is that we don't know enough in terms of what these drugs do to the chemicals that are in the brain that deal with being aware and alert and how that can impact a person. And that's the other problem. With alcohol over a period of hours, over a period of time, will eventually go out of your system. And the level of your being under the influence, the being impaired, the even registering can drop out. And you can precipitously look at a person's motor skills during that scale. You can't do the same thing with marijuana right now. And so that's a risk for you as an employer, because if you have an employee that tests positive for marijuana and you don't put them on a last chance agreement, and you're just like, okay, fine, whatever, you're on notice that you have a marijuana user. And what happens if your marijuana user drives one of your vehicles and gets into an accident? Or even if they're not driving one of your vehicles and they're using marijuana and they go out to lunch, but you knew that they are an active marijuana user and you didn't do anything. And they still wind up writing somebody down. Well, guess what? You're going to get sued. and your commercial general liability policy might not cover you.
Last chance agreement, they choose not to go into treatment. What are your thoughts about that?
Oh, if the employee, but in your last chance agreement, you're gonna say that you're gonna have to go into a substance abuse treatment program. If they refuse, that's one of the conditions.
Okay.
Fire, bye. Don't pass go.
I actually did call the ADA on this issue of accommodating. They told me that the only way to,
Now, you call the EEOC or,
well, I actually looked up the ADA.
Oh, you looked
I
it up.
called somebody within that organization. And,
well, that would be the EEOC, because the EEOC
This
is
was a
charged
while
with
ago, so-
enforcing the ADA.
yeah. So they actually told me the only accommodations that your company has to make is that if, say you go to treatment and you come back to work, and we probably won't run into this issue here in the Denver area, because we probably got about 2,012 step meetings a week around here. But if you're living in rural Colorado, you got one meeting a week and it's on Thursday night from 7 to 8, and your shift is from 4 to 12, the company has to give you the time off to
Right.
continue. your
And that would be an accommodation. So if the person gets into either an inpatient or outpatient treatment program, you, as an employer under the Americans with Disabilities Act, you're gonna have to provide an accommodation to allow them to do that, unless you can show that that sort of treatment program, for whatever reason, isn't a reasonable accommodation.
So if we're running a broader panel, say a 21 panel drug screen, and we can detect benzos and all the prescription drugs, is it the same application here for that if your employee has an accident and is under the influence of Xanax or Valium or whatever?
Percocet.
That same principle applies?
So
And they have a prescription.
I would have, okay, so the question is, what happens if you do a broad-based drug test and prescription drugs come up, some sort of prescription painkiller? What do you do in that situation? You know, can you put them on a last chance agreement, et cetera, et cetera? What I would do with that employee is, and the ADA lets you do this, is ask that employee to go to their physician and get documentation from their physician establishing why they're using these prescription narcotics and what the potential effects of these prescription narcotics, and can they safely perform the essential functions of their job when they are using these prescription narcotics. And so under the ADA, that is a permissible medical inquiry. You can ask them those questions. I want to terminate them or put them on a last chance agreement at that stage. I would wait until you get the information back from the employee's physician. Now, what happens if the employee doesn't provide you that information, or because they're illegally using the prescription narcotics, or they're abusing the prescription narcotics, and their doctor won't provide them that information? Then at that stage, I would say, if you can't substantiate your reasons to use this job, use this, I'm considering this to be a violation of our substance abuse policy.
Can a doctor do that for medical marijuana though too? Say that they can use it and still perform the functions of their?
Well, they can't prescribe it, so remember, they can't prescribe marijuana. They can say that, you know, because of their medical condition, they need to use marijuana. They can certainly say that, but guess what? You don't have to accommodate that use, because that's not protected use.
This is related to that, I think it's still the same thing, but I was just wondering if it's come up. So under the DOT regulations, right, when there's a positive drug test, it's really not the drug test that triggers the report back to the employer, it's the medical review office.
Right.
And so they are asking the person, is there any medical reason why you were positive for this drug? I just wondered if that's come up since it's a doctor. So they'll ask that question, was it prescription medication, what was the dosage, and they'll
Right.
determine if it was abuse or proper use. And my understanding is if it's proper use, they report it back as a negative test. Do you know if that's come up?
That's my understanding as well. I've had situations where the employer has found out, either the employee has voluntarily said that they're on Percocet, and we have to go through the interactive process with this employee under the ADA, and we have to make medical inquiries. And it takes a long period of time to go through it. But I can tell you what we did with that employee, because they worked for a construction company. We kept them from working in any sort of hazardous activity, operating machinery, power equipment, anything like that. We were not going to take that risk because we were on notice that this person was using a substance that impaired their mental functions and judgment. And we weren't going to take the risk of some sort of accident as a result of that. So,
In companies that have medical departments and safety-sensitive jobs, aren't people supposed to tell somebody in the medical department that they're taking certain drugs that could?
That is a great question. What I advise my clients to do, and at the application process, and also in the employee handbook, I put the burden on the employer. It's the employer's the employee's responsibility, that is, to disclose to the employer if they are using any substances that may impair their ability to safely perform the essential functions of their job. Now, notice, I said substances, not drugs, because when you start asking about drugs, you cannot ask your employees to provide a list of the prescription drugs that they're on. That violates the Americans with Disabilities Act, unless you have some sort of reason to believe that they are on something that could pose a direct threat to you, for instance, or a direct threat to the safety of third parties or coworkers. So, and you can certainly ask them under the law, are you currently using any substances that may impair your ability to safely perform the essential functions of your job? You can put that in your job application. You can put that in your employee handbook and make that an ongoing duty and responsibility, in particular, safety-sensitive positions. You could train your employees. If you're currently using any substances that could impair your ability to safely perform the job, you need to let us know. If they don't let us know that, we have at least acted as a reasonable employer to try to find out what sort of substances they may be using that could impair their ability to safely perform the essential functions of their job.
But if you had that medical department, a doctor can make that determination and say this person's taking this medication, but he can still work, handle heavy equipment or whatever.
Mhm.
Or the doctor may say, we need to take this guy from work, but in no case does management know that he's taking a drug that might impair him. I don't think. I think the medical doctor says we're taking him off of work for medical reasons, not telling them what the
That's if you have an organization with a medical review officer, that may be the case. I can tell you I handled another case where we had the employee's doctor say that this employee was taking Percocet and I think codeine as well, could safely perform functions on scaffolding and use power staplers and all this other stuff. And we were like, no, this is ridiculous. So we got our own opinion from a board certified occupational physician who said, no, there's no way that this guy is able to perform this.
Quite often you can
And we
argue.
relied upon our own opinion. And we didn't allow that guy to go back up there.
Quite often you'll get an argument between the family doctor and the MRO.
Yep.
But he says he can be on and the MRO says, no, he's not. He's protecting the company, not the individual.
But those issues are gonna start coming up with medical marijuana then.
Oh, yeah, I mean, they are, and I think it's important that you focus on your policies and that you are consistent with your policies, and that you educate your employees about what your expectations are under your substance abuse policy. Where you get into problems is when there's not clear communication and you're not setting forth clear expectations to your employees. I think we're going to wrap up. I want to let you know that my department, Sherman and Howard, we're having our annual labor and employment law seminar on April 24th at Sports Authority Field. It starts at 7:30 in the morning. It's an all-day event. I'll be talking on marijuana again, but my partners and other colleagues will be talking on all sorts of employment and labor issues that affect HR folks. If you have SPHR or PHR certifications, we'll be offering credit. If you have in-house lawyers, we'll be offering continuing legal education credits. If you or somebody from your organization wants to attend this conference, we normally charge $150 for it, but if you send me an email, I'll waive your registration. And that's breakfast and lunch, and that's April 24th.
And your email is?
It's on the material, but it's VNAP, and that's KNAPP at ShermanHoward.com.
The website where you said we could get these handouts,
And
It'll
Eagle
be,
was.
Colorado.
And what day is that workshop?
April 24th.